Hi, this is Heather Meeker. This is a presentation on how to negotiate a contract. This is part of a series of presentations on very basic legal transactional matters that I hope will help people who are just starting out in a transactional practice. Let's get going. Now, I don't know about you, but when I started out as a transactional lawyer, I was pretty intimidated by the need to negotiate contracts. I didn't feel like I was a good negotiator. I didn't feel like I knew anything about it. And I didn't feel like I'd learned anything about it in law school or any of my other training. If you learn something about it, then you're ahead of the game. But this presentation is intended for people who really don't know the basics of negotiating a contract. And if you're feeling at all intimidated or fearful about the process, you should know that having this basic knowledge is extremely powerful and will help you overcome whatever reservations or fears you might have. So the objective of this presentation is to arm you with some information that will make the process easier. As you negotiate contracts, it gets easier and easier as you go along. And I would say that at this point, I really like negotiating contracts, whereas when I started out, I didn't think I would like it at all. So I hope this presentation will be helpful for that. Okay, first let's talk about process. This is how a contract negotiation usually goes in most transactional practices today. The deal is initiated by business people, your clients, who decide that they want to do a certain sort of deal. And they will create something that describes in very broad strokes the terms of the deal. And that document can be called a lot of different things. It can be called a term sheet, a letter of intent, or a deal memo. And there are other terms that people use as well, but they all pretty much mean the same thing, which is a rough outline of the deal points, but not the final documents that people are going to sign. And you'll find as you go along that your clients will have a great range of practice in giving you just a few sentences to some very detailed terms. And one of your jobs is to help your clients refine those terms and to spot issues and make suggestions so that you can resolve problems early in the process and not later in the process when you're trying to hash out the definitive documents. So that's the first step. Your client will come to you and say, I want a deal that is X, and they will communicate what X is somehow to you. Usually they've traded emails or documents with somebody on the other side of the deal in order to triangulate on a position. Okay, next, once the parties have settled on the basic deal points, usually in writing, usually in a very informal style, you will start creating the definitive documents. Now, the first thing the parties have to settle on is who's going to create the first version of the documents. You have to be clear about this because if each side tries to prepare their own, that's going to slow down the process a lot. And we usually say that the side that is creating the first version of the definitive documents has the pen. And usually the pen transfers from one side to the other over the course of a negotiation, but occasionally one side will want to produce every change to the documents that there is. It's really based on context. So one side drafts up the definitive documents. And by the way, when I say definitive documents, I mean the documents people are actually going to sign. They are supposed to embody the points in the term sheet, but also add all of the details that you need for a full contract. And it also is a process to put the terms of the term sheet in a more formal sort of legal language so that they can be competent documents to sign as contracts. Then, once the party that has drafted the first version of the definitive documents is ready, they send the documents over to the other side who reviews them. And the other side will then generally ask for some changes or some revisions or some clarifications. And this is done either by making what we call a red line of a document, or by sending comments back to the original drafter, who then has the task of reflecting them in the documents. A red line, by the way, is a form of document, and we'll see an example shortly, that shows additions and deletions from a prior version. And in transactional practice, getting red lines correct and keeping version control is a very important thing. It's a process that you learn over time, and it can be a little bit challenging to do, but it is absolutely accepted in transactional practice that when you change something, you show those changes to the other side so that they can easily and quickly review what changes that you have made. So the process goes on, and the two parties will usually exchange versions back and forth. It usually goes from one to the other until they settle on an exact form of definitive documents to sign. The next few slides show you some examples of how this works. So this is an example of what some deal points might look like for a deal for two parties to get together to collaborate to develop a flying skateboard product. You can see that there are a few deal points here. One party will provide software, the other will provide hardware plans. They're going to set up a joint venture entity. One party will own 60% and the other will own 40%, and so forth. And this level of detail is actually pretty customary for what you might get from a client who has traded some emails back and forth with the other side about what they want in a deal. And this information can be pretty skeletal, and it's your job as a lawyer to help them fill in the blanks. Now here's an example of what a more formal term sheet might look like. A term sheet is a document that is not a binding contract, but it sets forth with some detail the deal that the parties are going to do before they write up the definitive documents. By the way, the reason that you go through this in stages is that it will cost a lot more money to fix problems that are in the definitive documents than problems in the term sheet. The term sheet is intended to get everybody on the same page about the broad strokes of the deal in order to save time and energy doing the definitive documents. Sometimes a detailed term sheet is used in deals, and sometimes it's not. Sometimes you go directly from the bullet points to definitive documents, and sometimes you go through this interim term sheet stage. Formal term sheets are usually used for larger deals. And if you write a formal term sheet correctly, there will not be a lot of work in creating the definitive documents. You'll mostly be adding legal terms, what some people might call boilerplate, but they can be very important terms that are not the basic business points of the deal. A formal term sheet might be revised by one side and the other until they get to agreement, and then at that point you move on to the definitive agreement, meaning the contract that the people are going to actually sign. So this is going to be a binding contract, and this is usually a longer and more formal agreement. Next, you get to the process of trading drafts of the definitive documents, and on this slide you can see an example of some changes that one side has made, and this is what we call a red line. By the way, it's referred to as a red line because back when people did these by hand, they used a red pen to mark the changes. Some people now call these black lines because they're always created automatically now. But as you can see, one side has added some things and deleted some things. The things that are added are underlined. The things that are deleted are stricken out. And they will send this to the other side to reflect what they are asking for in the document. By the way, if there are significant changes being asked for in a revision of definitive documents, you might accompany the document also with some additional deal points or outlines so that the people that are reviewing your changes will know why you made the changes that you made. But often when people trade documents, there's no additional explanation because the changes speak for themselves. Now that you've got a sense of how this works, here are some pointers about the process. First of all, you should always send accurate red lines. Sending inaccurate red lines is considered unprofessional or, at worst, fraudulent. And so, if for any reason you can't produce an accurate red line, you need to explain why. And it's your job as a transactional attorney to produce correct ones. When you are working on a draft and trading it back and forth with your client, you might put comments in the draft intended for your client, legal advice for your client, and also your client might put questions to you. Those types of crosstalk comments should always be removed before you send the document to the other side. Also, you should always make sure you're copying in the right people on emails and including the right people in calls and meetings. This is one of those things that is deceptively difficult to do sometimes, and it's really the mark of some very good attorneys that they know very well how to get the right people to meetings and how to include the right people in discussions back and forth on contracts to get the deal done. Another thing that is important as a matter of custom and practice is that if you have a conversation like a call or a meeting and you agree to a point in the discussion, and then it's your job to reflect those discussions in a red line, that you accurately reflect the discussions that you had in the red line that you create. And if for some reason you can't do that because your client has changed their mind or because you've found some problem with the discussions or lack of clarity, you should explain why you haven't accurately represented the discussions in your red line. When you send documents out, you should always explain what you're sending, and it's usually something on the order of, I've attached a revision of the agreement in clean and marked copies. And if there are many versions floating around, which happens quite a bit, you want to be specific about which version you are redlining against so that everybody who's looking at the red line knows what they're looking at. And then finally, I would say that in contracts, it's common practice, if you have a fact that you don't know whether it's been agreed on or whether it's correct, you put it in brackets so that people can review that in the document. And it's always best to try to propose something rather than just leaving blanks. What I always like to say is, if you leave a blank, the chances that the contract is done are zero. If you put something in, there is a chance that it's correct. So always try to make suggestions and move the deal forward. One thing that I would say about this overall is that as a transactional lawyer, of course, it's your job to represent your client, but it's also your job to get the deal done. You might have to put the brakes on if you think the deal is very bad for your client, but mostly the client is relying on you to manage the project of getting the deal done. So always do what's necessary to move the deal forward and suggest next steps and make things happen for your client. Here are some examples of things not to do. These are a few things that you might do incorrectly when you're revising documents. First, you can see in the balloon comments on the right-hand side of this slide, this is some crosstalk between you and your client. The client said, do you think they really mean this? This doesn't make sense. And you might say, I think they will agree to 3 years instead of 1. Obviously, this kind of strategic discussion does not belong in any communication sent to the other side on a deal, because it's confidential and privileged conversation between you and your client. You can also see here that the term of the agreement, which is a very important provision of any agreement, has 2 options, 1 year and 3 years. And it's better to propose 1 unless what you're trying to indicate is that you might be willing to accept either in different circumstances. What you should do if you want to signal that you want to discuss the point, is to pick the one you want and put it in brackets, but don't do both of them. You can also see at the end of this slide that in the red line, the last phrase has been apparently added and deleted, which is confusing. If it shouldn't be in there and it was in the last draft, you need to delete it, meaning it should be struck out. If you intend to add it, it should be underlined if it wasn't in the last draft. Because both have been done here, it's hard to tell what has happened since the last draft. So here are some pointers about how to behave in negotiations. These pointers will help you if you're feeling nervous or not confident about negotiations. They should help you understand that the negotiation process is nothing to be afraid of, and it needn't be unpleasant. In fact, I would say that most negotiations of transactions are very collegial. And by the way, one of the reasons for that is that it is most effective to be collegial. I'll talk a little bit more about that in a moment. But these are my personal philosophies about negotiations that have served me well in my career. First, work the problem and not the people. In other words, it's not about looking good or appearing smarter than other people or winning on a personal level. What you need to focus on is the substance of the deal you're working on and getting the best result for your client. And so if you find it difficult to deal with people, or if other people are making it difficult for you, you can always deflect concerns about interpersonal interactions by focusing on substance and not focusing on things like whether people are treating you properly or whether they're being nice enough to you and so forth. You really need to let a lot of that slide off your back if it happens. But the point is that if you work the problem and not the people, you'll be more effective, and you'll find that people who focus on substance and aren't playing games do a lot better in negotiations. Second, always be civil to everyone involved in the deal, whether they're on your side or the other side. There's no need to be unpleasant or sarcastic or aggressive or insulting or anything like that. And in fact, it will be a very ineffective way of conducting negotiations. And by the way, I'll just add, you should be civil to everyone involved, whether they're lawyers or clients or support people or what have you, because you'll find that the political capital that you build up with people in your interactions with them will serve yourself and your clients very well. Next, once you concede a point, don't renege on it. By the way, this is, I would say, partly a cultural question because people in different cultures feel differently about this issue. But specifically in U.S. practice, once you concede a point, you're not expected to go back because that takes people further away from getting to an agreement than they were before. So you're expected to raise all your issues as early as possible. And once you've resolved an issue, you're not expected to reopen it, except perhaps if the resolution of a different issue changes how that resolution works. Another thing is to focus on what's important and don't bother with things that don't matter. Some lawyers are supposed to be detail-oriented, but you really need to focus on what's important to your client, what's going to matter to your client. Getting everything perfect is a great goal, but in fact, it's often not a very feasible goal, and you have to make your contracts good enough so that they're clear and understandable and they represent the deal that's been struck. But it's not important to make them beautiful, right? You need to make sure that they are serviceable. And so don't get too focused on things that really don't matter to the substance. Next, credibility is everything And this goes to being civil and working the problem and not reneging on points. Once you lose your credibility in a negotiation, you've kind of lost the negotiation. The credibility that you build up dealing with other people during a negotiation is extremely important. And finally, the other side are opponents, but they're not your enemies. And so there's no reason to consider them to be bad people or to treat them badly the way you would an enemy. You want to be civil to them all the time. And here are some additional negotiation pointers. First of all, knowledge is power. If you are concerned about your performance in a negotiation, the best thing you can do to prepare in advance is to know as much as you can about your client, about the other side, about the deal, and about the facts surrounding that. And you'll find that if you do your homework, then you can focus on substance and you'll be less self-conscious and less concerned about the dynamics of the situation. The next is be prepared to walk. In fact, most deals end up getting done because most clients, by the time they are at the term sheet stage or they send a deal to you, they're pretty invested in the idea of getting a deal done. So relatively few of them fall apart. But you have to know at what point you're ready to walk. And the acronym that's used for this in negotiation theory is BATNA, or the best alternative to a negotiated agreement. In other words, what are your options if you don't do the agreement? Make sure that you have come to an agreement with your client about what is the most that you're willing to agree to in a particular situation. Next, don't take any of it personally. Negotiations are not about you. They're about the contract you're negotiating. And so, if you think people aren't treating you quite right or they're unpleasant to you, it's best if you just let it roll off your back. Obviously, don't let people abuse you, but you got to kind of roll with the punches when you're doing negotiations and just keep in mind that it's really not about you or your personality. Lots of people in negotiations talk about what is fair, and there's a broad range of what is fair in business. So while you certainly can say that's not fair, that's not reasonable when somebody proposes something in a negotiation, it's not a terribly effective negotiation strategy. So try to see both sides of the issue and understand why people are asking what they're asking for. Here's a really important pointer. If you're negotiating a point and the other side concedes, all you say after that is, "Thank you, I appreciate that." You don't go on talking. You should stop talking at that moment. Some, particularly junior negotiators, have a tendency to, once they win a point, give a speech about why they should have won. And really the only possible outcome of that is that you will say something that leads the other side to change their mind. So once you win a point, say thank you and stop talking. One of the classic strategies in negotiations is to ask the other side to make the first offer. And if you do a negotiation workshop or something like that, you will usually hear this strategy recommended, particularly if you're negotiating something like a price. You always ask the other side to make the first offer to make sure that that you don't undercut your own situation. When you're in negotiations, don't criticize your client. Even if your client is not making you happy or misbehaving, you're representing your client, and so you need to look like you're a united front. So don't say negative things about them, even if you feel like it sometimes, to the other side. That's not appropriate in a negotiation. Now, if you look at negotiation theory, you will see people saying things like, look for win-win situations. And the question you should always be asking yourself is not why you want what you want, but why the other side should also want what you want. So if you can think of something that makes your position a positive for both sides, that is the easiest way to win a point in a negotiation. And as I mentioned before, always keep the process moving because it's your job to get the deal done. Well, that's it for this short presentation on how to negotiate contracts. I hope you found it helpful. If you would like to read more about negotiation, the most famous book on this topic is called Getting to Yes. It's my favorite book on the topic, and I think it's the #1 bestseller of all time on the topic. Take a look at that. It's very helpful and talks about things like win-win strategies. Finally, here is a link to my book on technology licensing. If you are in the technology transactions practice and you want a primer on the basics of technology licensing, you might want to check this out on Amazon. So go out and negotiate some great agreements for your clients and have fun doing it.